Lordship is here. Please, give welcome, huge claps.
All becomes right, sir. Yeah, even right.
My lord, welcome back.
Oh yes, thank you.
Rahul, please just play it. No, not necessarily. No need to rise. This Friday, this is our Friday group music anthem. Sir was released this at ISIL. That was 100th Friday group meeting. At the same time, on the same day, this is another book was released before Lawyer's Role in India's Freedom Movement. This is several advocates, they given articles, including Nagamuthu sir on Article 32 and Karpagam sir and other few prominent members. We'll start with the bouquet of flowers. Rahul and Amit will come and give a bouquet of flowers to Lordship. Naveen, please come.
Thank you. Thank you.
I request Sridhar Podras will give a felicitations to Lordship with a shawl and all. Jyoti, please come. Give a book of flowers to Lordship. Come, Deepa and Saket also, please come quickly. Pallav, you also join, please. Come quickly. Huge claps. Earlier, first Mukesh Nasaji has requested me to, he will hand over this thing. He was kind enough. He was I was with sir at that time. Please, sir.
Mukesh one used to be my court master.
Lordship, today's is a 285th Friday group meeting. In fact, it's a very prominent topic. Everyone is appreciating and praising the way it's on Justice Subba Rao, 9th Chief Justice of India. The topic is the celebrated dissenting opinions by Justice K. Subba Rao. That is our this thing. And Lordship, you addressed our Friday group, the power of contempt in the administration of justice, on 4th January 2019. That is 100th celebrations. That was actually our beginning, in fact. Friday group has taken a very comment. Justice Narasimha was kind enough to introduce myself, and then Lordship was this thing. Then after that, 150th also Lordship addressed our Friday group. The topic was Judicial Contribution of Justice P.M. Bhagwati. For the total, your YouTube contribution is Lordship, 32,830. As of date, our Friday group YouTube channel, we are aware that we have our own channel, 2,000,001 views we have. And subscriber 38,000. Going well. Now, Lord, I request you, Lordship, will take initiative today's this thing. We want eagerly hear this thing. Sharp 4 o'clock, sir has to leave, so that we have to maintain something. That's what we have not given any opportunity to any other. Kindly excuse us. Sir. Basan sir is here, Nagamuthu sir is here, Justice Karpagam sir is here. Sir, you can come. Sir, you can come.
Sorry, I got held up in traffic.
Should we begin? Sir, you will. Sir, mic.
Yeah, one second. One Lordship.
Keep it.
One second, Lordship.
All the Lalit Senior Council, all the learned advocates, members of the Supreme Court Bar Association, and the convener of this Friday group, Mr. G.Seshagiri Rao, Seshu, and his team. It is true that I have been associated with this Friday group. This is my third, perhaps I think, lecture before the Friday group. And Seshu gave the account. The first one was regarding contempt powers, the second one was regarding contribution by Justice Bhagwati. These are some of the leading lights that we, members of the bar, keep sort of idolizing. Justice Bhagwati was one of them, and today what we are going to discuss about some of the dissenting notes by Justice Subba Rao was one of them. In fact, Mr. Fali Nariman went on record to say that if at all there were two judges who made significant contribution for the advancement and development of law by the Supreme Court, there was Subba Rao and the second one was Krishna Iyer. That's how Justice Bhagwati. We have always seen that very well this court has to sit in composition of benches, 3, 5, 7, 9, so on and so forth. At times, whatever has been decided by 3 judges is not accepted by 5, not accepted by 7. We have seen that Rani construction, Mehul construction, SBP in arbitration law, so therefore 3, 5, 7, every time getting upset. We have seen some of the leading dissenting notes. ADM Jabalpur, Justice Khanna's dissenting note, which became a celebrated dissent, though not accepted by the other 4 members of the bench. But subsequently, the entire legal community and fraternity has come to accept whatever Justice Khanna laid down to be the correct exposition of law. And then later, a larger bench expressly found that what Justice Khanna said was the correct dictum of law. Similarly, the very first case, Anwar Ali Sarkar, where Justice Fazal Ali's dissent was a very well-known dissent, which later became the law of the land. So we have always had these dissenting notes, then paving the way or showing the path of light for the subsequent generation of judges or the legal fraternity. Do you know Justice Subba Rao has authored 62 dissenting notes? That's by far the highest by any judge in the Supreme Court. 62 dissenting notes. And some of them have actually paved the jurisprudence to develop in a particular fashion, adopting what Justice Subba Rao came out with an idea. So therefore, whatever was thought of by that person was later adopted by the fraternity. Two things just momentary so that it gives you the glimpse of that man. At the initial stage, in the young days, Subba Rao joined the lower judiciary as a Munsif. Later resigned and set up practice in Madras High Court, Madras Bar. Was then called to the bench, so became judge of the High Court, then Chief Justice of Andhra, then to the Supreme Court, retired as Chief Justice of the Supreme Court. So for over about a year and a half, he was Chief Justice of this court. And perhaps till this date, the only person who had the distinction of contesting the presidential election. Of course, we have had recently Justice Sudarshan Reddy contesting the Vice President's post. Hidayatullah successfully contested. So these are two other exceptions, but the highest office, which is the office of the President, Subba Rao contested against Zakir Hussain, who finally won the election. That's a different part of the story. So we are now here to consider what are the dissenting notes of substance. It is impossible to deal with all 62 dissenting notes in the shortest possible time. So therefore, I have picked up 5 or 6 dissenting opinions of Justice Subba Rao, which according to me are path-breaking ideas. He became judge of this court sometime in 1958, was a judge of this court for 9 years and retired as the Chief Justice. There are some of the authors have said that Subba Rao as a puisne judge, as a junior judge, used to be the dissenter quite often. But when he became senior judge and became the Chief Justice, there are actually the craftsmanship of that man was such that he was able to convince his brother judges to be on the same side, and there are hardly any dissents when Subba Rao was the Chief Justice. Be that as it may. So therefore, let us start with some of the greatest ideas which Justice Subba Rao came out with. The first case is Radhesham Khare, which is a judgment of 1959. 58 he became judge. 59 SCR is the reported judgment. So therefore, within a year, there was this dissenting note by Justice Subba Rao. What was Radhesham Khare? In a municipal committee coming from Madhya Pradesh, the office bearers of that municipal committee, the president, the vice president, they were facing charges of misuse of office. So independently, some kind of notices were issued to them. And at a point of time, after being satisfied that perhaps I think some emergent action is necessary, the concerned authority passed an order under section 53A of the relevant local statute. 53A gave the power to the officials, the concerned officials, statutory authorities, to appoint an officer who would then discharge the duties which the municipal committee was obliged to discharge without dissolving the committee. So therefore the office bearers would continue, but the powers would then get vested in this particular official who could be appointed. There was another provision which was 57, that in case you wish to dissolve the municipal committee, then there was a separate power which was given to the statutory authorities. 57 came with a rider that you must hear the person's concern. But 53A was without that condition, that you need to hear the person's concern. It only postulated that it must be a reasoned order. Beyond that, the statute was completely silent. Now, one of these submissions which was advanced was that, look here, these people, the officials or the statutory authorities never gave us any notice. We were never called upon to show cause. We were never called upon, given an opportunity to say that why this particular drastic order under 53A was not necessary. And this was answered by the majority, speaking through Chief Justice Das, that 53A and 57 operate in different fields. Under 53A, there is no statutory obligation to hear you. In any case, on record, there were certain kind of allegations against those persons who were the office bearers of the municipal committee, and therefore there was enough evidence on record to say that they were aware of the charges against them. Of course, it was never focused in the fashion that 53A is getting invoked against you. What do you wish to say? And therefore the majority judgment, which was by Chief Justice Das, did not result in any kind of relief so far as those individuals are concerned. Justice Bhagwati, who was also one of the bench members, he said that you had sufficient notice. Justice Kapoor said that intent of 53A is not to give you elaborate kind of hearing and everything. It's only an emergency power, because why? It is only the officer can be there in the charge for about 18 months or so. So it was a temporary in nature. S.K. Das also told the same line, and there comes the celebrated judgment of Justice Subba Rao. And there he says that if a person is to be condemned in this society, we will not allow a person getting condemned unheard. And therefore, the postulates of natural justice would require that the person must be given every opportunity to represent against the proposed action. Of course, he went on to say that what is the nature of that order, so therefore he said that you are going to decide the question, the status of those persons, so therefore you are essentially in the realm of what is called judicial order. Whereas the others said these are purely administrative functions. So mark this, that Bina Pani Dai and other cases that we have then thereafter come to accept as part of our jurisprudence, that no man should be condemned without being heard. We accept this as a basic principle. And this was something which was, by way of a dissenting note, Justice Subba Rao, who was barely about a year or old in this court, and the junior most judge in that constitution bench came out with that dissenting note. So therefore, first dissenting note that we have actually seen is Radhesham Khare, which was a case from Madhya Bharat of CPM Berar. Then comes a case which is called Basheshwar Nath. have what is called our fundamental rights are similar to what are the provisions in the American Constitution. Our Article 14 is nothing but their 14th Amendment. And the ethos which is developed in America is that it is possible, it is permissible for an individual to waive his fundamental rights. Now take for instance, if my property is getting acquired, I may not choose to work in appeal. I may not challenge that. So therefore I may as well say, very well, take it over, then whatever is the compensation, give it to me, rather than questioning that quantum of compensation or the principles of compensation. So there could be waiver of constitutional right which is under fundamental right. So therefore it was being projected in Basheshwarnath that very well same principles must apply to Part 3 rights which are enjoyed by the citizens of this country. Most of the judges said that yes, other rights you can, but Article 14 is impossible to be waived, so therefore that's your basic fulcrum of the entire constitution and principle of equality. So therefore minus that, perhaps I think anything can be waived. One of the ideas which went in that discussion was that look here, if a right or a privilege which vests in an individual as against the collective kind of community right, and that individual wishes to waive that right, what is so wrong about it? If it is a collective right, one can say that where does he get the power to waive that kind of right? But so long as you are in that realm of what is called purely individualistic perspective, it is possible to waive that. So therefore, some of the judgments from the majority which are essentially, and the Chief Justice Das relied on what is called Pesikaka and said that it is possible to open to waive. Justice Bhagwati was the only judge apart from Subba Rao who said that not open to waive any of the fundamental rights. The other judges said that yes, it is possible to waive, which are individual rights. Subba Rao and Bhagwati were the lone dissenting notes saying that no fundamental right, no Part 3 right can possibly be waived by a citizen. Now that has also become part of our ethos and the jurisprudence, and we say that these are not rights which can be waived. And that's exactly what is Bandhava Mukti Morcha. Somebody may have sort of, given over his liberty in return of some money which is 2,000, 3,000 and would have agreed to say serve that person all through his life. So therefore, that has become also part of our ethos that fundamental rights are not possible. They cannot be waived even expressly by an individual. And that has also become something like a matter which has stayed and which has become part of our jurisprudence. This is also a case of 1959. So therefore, just mark this within a short span of 2 years. Justice Subba Rao. Now the third one is also 59, which is that famous Pandit M.S.M. Sharma case. What happened in that M.S.M. Sharma is that there was a news magazine which was being published by somebody from Patna called Searchlight. It so happened that a member of the Legislative Assembly of Bihar leveled certain allegations against the then sitting Chief Minister and said something on the floor of the House. Whatever he said on the floor of the House was reproduced by this M.S.M. Sharma in his Searchlight news magazine. to say that these are the charges against the chief minister, etc., etc. So therefore, according to him, it was a faithful and truthful reporting of whatever happened on the floor of the house. But it so happened that because of these skirmishes which were there and the political kind of, the debates which happened thereafter, the Speaker of the House decided that all those remarks be expunged from the record. So theoretically, there was nothing on record which could tally with what MSM Sharma had reported in his searchlight. Then he was issued what is called notice of privilege by the Patna Assembly, that is Bihar Assembly. And he was called upon to be present before the Privileges Committee to answer the charge that why did he report something, number one, minus the permission given by the Legislative Assembly, and number two, something which is not truthful. He rushed to this court in 32. The matter was heard by a bench of 5 judges, Chief Justice Das speaking for himself and other 3 judges. Just a matter slightly on aside. Under 194 and 105, 194 applies to state assemblies and 105 applies to the parliament. There is one codified privilege which is under 105 and 194, which is that there shall be freedom of speech and expression in the House. Number 2, every member shall be entitled to cast his vote or say anything on the floor of the House, and that he shall not be proceeded against in any court of law for whatever he says on the floor of the House or the vote that he casts in any of the proceedings of the House. These are 2 privileges which are codified. 1053 and 194.3 then specified, or even today specifies, that it shall be open to the Parliament in 105 and to the state legislature in 194 to lay down the privileges which according to them should be enjoyed by the House and the individual members. So one part is actual codified, 2, power to codify, and third, till you codify, all your members shall enjoy the privileges and immunities which the members of the House of Commons used to enjoy as on the date when the Constitution of India came into force. So 1053 and 194.3 operate in what is called a nebulous idea. That whatever was enjoyed by members of the House of Commons is enjoyed by you. So therefore, first and foremost question, whether did they enjoy that privilege? So you have to first establish that did they enjoy it? Was it being enjoyed as on the day when the Constitution came into force? And then only as a derivative idea one can say that very well now you also enjoy the same privilege. So therefore a lot of debate went on whether there is any right in the House to stop publication of fair reporting of whatever happens on the floor of the House. Now, one of the privilege claimed by the Assembly was whether right, good, bad, indifferent, whether truthful, faithful or not, we have every right to stop any publication which is done without our authority. So we are the supreme kind of august body, and we have every authority to stop publication. So they place the matter at the highest pedestal. And that was to a certain extent accepted by the majority. One of these submissions was that 105 opens with, subject to the provisions of this constitution, so and so, there shall be freedom of speech and expression. But then one of the ideas was, does it apply only to one or does it apply also to three? So there is a debate going on that issue as well. Now the moment if you say subject to the provisions of this constitution, part 3 will definitely come in focus. So therefore, can that privilege be claimed in violation of my right under 21? What does 21 postulate? That life and liberty shall be protected save and except by a procedure established by law. And you yourself are not clear whether you have that privilege or not. Where is the procedure established by law? So who has done, what are the contours of that privilege? And to what extent I can be punished? Whether am I to be punished till the rising of the house, or am I to be punished for 3 years, or 4 years, or 5 years? Who has laid down the punishment norms? There is absolutely nothing. So therefore, where does that right belong? And can you go and violate my 21 right? So the majority goes on to say that yes, 21 is something which we will certainly protect, but 19(1)(a), you do not have that right. Because the moment you speak something, there are inherent limitations, and some of the limitations are to be found in the Constitution itself, and therefore, sorry, you cannot. Justice Subba Rao, in his dissenting note, relies on one of the earlier decisions of Gunapati, which was dealt with by a bench of 5 judges. There what happened is, a person for alleged breach of privilege was picked up, breach of privilege of UP Assembly, was picked up by the police and lodged in the police custody, but not produced before the magistrate within 24 hours, which is the requirement under one of the postulates of the Constitution. So then the writ petition was filed in this court with the allegation that I am not even being produced before the magistrate, and my continued detention must be only under the order or express directions by the magistrate. There is no other power. The Attorney General who appeared for the state conceded the matter and said that very well, yes, because the person concerned was not produced before the magistrate within 24 hours, the continued detention is bad. Now that judgment was relied upon by Subba Rao to say that if this could be held bad, which means part 3 gets attracted straight. And if part 3 gets attracted, Article 21 has to be the repository of everything. And the person concerned not only under 19(1)(a) has the right, but also under 21. And if there is no procedure established by law, then the man is entitled to be released forthwith. But of course, this was a dissenting note. Now 2 or 3 years later, 59 is this judgment, sometime in 64 came that UP Assembly case, which was a very famous case, in re Keshav Singh, or in re what we call UP Assembly case. 7 judges of this court sat there, headed by Justice Rajendra Gadkar, and they had a very, very situation of dilemma. In a similar case, somebody was sought to be proceeded against by UP Assembly that time. He went and filed a habeas corpus petition before the High Court through an advocate named Solomon. 2 judges of the High Court granted him interim relief. The moment the bench grants interim relief, the next step of the Assembly was to issue notice of privilege to the judges as well. That it was a special matter within our cognizance and competence. Who are you to consider that? So the breach of privilege notice was issued to this Solomon, the advocate, and 2 learned judges. Now there was an impasse. What does one do? A bench of 28 judges of Allahabad High Court sat. perhaps the largest bench in the independent history of this judiciary. 13 judges we associate with Keshwanand Bharati in this court, but in that court it was 28 judges. And they granted the relief to those 2 judges and the advocate. Now the situation had reached such nebulous and idea that anything can happen now. If those 2 judges could be proceeded against, there is likelihood that 28 may also be proceeded. So the Union government then sought advisory opinion of this court on certain questions, that whether the judiciary has a right even to interfere while the proceedings for breach of privilege, etc., are being undertaken by the concerned house. While answering those questions, and if you see that judgment, it's a craft of Mr. CJI comes to the fore. CJI appeared for UP Assembly and he said, you are sitting in advisory jurisdiction, you can't issue notice to me. UP Assembly. I am appearing on my own volition before you and seeking to assist you. But whatever you say, because I am not a party to the list, can never be binding on me. And he appeared to assist the court. Now it was a very catch-22 kind of situation for the judges, because there was this 5-judge bench combination. Majority said that the existence and efficacy of privilege is the prerogative of the House. So therefore, where do we now interfere in the matter? Because the majority judgment was this, and that was a judgment in a regular list before the court. Today we were sitting in advisory jurisdiction. And yet that bench of 7 judges, they don't say in clear words, but they adopt whatever Subba Rao had said. They don't say in clear words. It was impossible for them to say that, because the moment you said that we are accepting minority, it means that you are overruling the majority, which could not possibly be done while sitting in advisory jurisdiction. So they adopt whatever Subba Rao had said, and adopting that, they grant the relief, naturally under 21, to both the judges and that Solomon. But the person concerned, the accused, was left to lurch. So therefore you won't appear before the privileges committee. Whatever happens will certainly take the due course of time. Now that very judgment of Justice Gajendra Gadkar has become now what is called the watermark in our jurisprudence on the point, and which was adopted by Justice Sabharwal in that Raja Rampal, which is cash for vote. 5 judges, they have adopted everything. And if you see the conclusions drawn by Justice Sabharwal, they are exactly in tune with whatever Subba Rao had said. So therefore, this is how the clock turns completely, and whatever was the dissenting note by Justice Subba Rao becomes part of your ethos or the jurisprudence. Again, this is the judgment of 1959. So credit must be given to Justice Subba Rao to come out with these dissenting notes in the very first few years as part of this court. Then we go to the next judgment, which is Khadak Singh. And that's a very, very celebrated judgment. Today we have come to accept what is called right of privacy. We can't even countenance an idea that somebody can look into my data on the mobile. My data on the mobile is my right of privacy. It is only accessible to me. Even under police powers, you are not supposed to do that. Even if you were to interfere or intercept my telecommunication or conversation on telephone, you need to have an express order from the government. And it's only the secretary level officer who can certify and grant that kind of permission only on certain kind of norms which get satisfied or established. In Kharak Singh, there was one police regulation from state of UP, which is 236. It entitled and empowered the police machinery to pry on or to spy on a person of doubtful criminal antecedents. So they could have a picket outside his home. They could have what is called nighttime domiciliary visits at night. Suddenly at 2 o'clock in the night there could be a knock on your door and somebody may say, "Oh, are you still there?" "Yes, very well. We just wanted to check whether you are inside the house or not." Any moment, whether he was going for his normal shopping errands or something, could be seen by the police who may accompany you. So it was this constant vigilance and surveillance which the person was subjected to under this 236. Of course, the man concerned, Kharak Singh, was at some stage was an accused in a charge of dacoity, but was acquitted. So therefore, he was a doubtful character, no doubt about it. But nonetheless, could there be any surveillance like this, which is authorized by the express provisions of the statute? So therefore, the challenge was raised to that. This is Rajgopal Iyengar speaking for himself, Chief Justice Sinha, Justice Jafar Imam and Mudholkar, all 4 judges, found that this nighttime vigilance, domiciliary visits at night, where you are directly infringing somebody's personal right, is definitely bad. But the other provisions, that you could be tailed, that you could be followed, that you could be spied on, that you could be, every time your activities could be monitored in the sense only by way of writing, not trying to monitor your ways in a sense that please don't do this, please don't do that, etc. He would be left alone, but at the same time there would be constant vigilance, surveillance. The majority found that right of free movement, yes, under 19 you have every right to move anywhere. They may accompany you, but that doesn't infringe your right. So therefore, go about with your movements. There is no direct impediment or infringement so far as your right of movement is concerned. And therefore, except for those domiciliary visits at night, where you are definitely bothered in the dead of the night at the whims and fancies of the police, anything short of that was perfectly valid. This was Kharak Singh majority. Subba Rao, again in my right. And what he said, Subba Rao with Justice G.Seshagiri. So he wrote for himself and Justice G.Seshagiri. So 2 judges were in minority. And they said, not just that provision which was that domiciliary visits at night, but entire regulation is bad. And that regulation is bad, why? Because you have, under your 21 right, every right to be sort of left alone. Any infringement, even if by way of, somebody spying on you with goggles, is also an infringement. And there they say, come out with, there is just one passage. I can't say that that passage was supposed to be the fountainhead for the subsequent jurisprudence. This judgment is good and important on two counts. Number one, what is privacy? Because it is this corrupting view that you cannot be even followed by a police officer over the shoulder. That is your right of privacy. That is your right that you must be left completely alone. Was something which was acknowledged in corruption, which then became in Puttaswamy, etc., became the law of the land subsequently. But there is one passage, and that passage says, 19(1)(d), yes, you have a right to move about, and that right of movement should not be with any of these obstacles or the infringements or impediments that somebody is spying on you. But that is also violative of your 21. Now, if you recollect as students of law, what happened in Anwar Ali Sarkar was, Chief Justice Kania, Harilal Kania, the then Chief Justice, came out with this theory that every fundamental right under Part 3 is like a separate compartment. And whenever any person comes with an allegation that his fundamental rights are getting violated, the court's concern must see which is the proximate right which gets violated. Anwar Ali Sarkar was a case where somebody was challenging his order of detention issued by State of Madras. Not Anwar Ali Sarkar, sorry. A.K. Gopalan. I'm so sorry. It was A.K. Gopalan. In A.K. Gopalan. So, because there is a very beautiful article which was written by somebody saying that through A.K. Gopalan, two Nambudris entered the court. One through the court registry, which was A.K. Gopalan, and the other one was M.K. Nambiar, who appeared in the very first matter before the Constitution. So it was, sorry, my mistake, it was not A.K. Gopalan, it was this A.K. Gopalan, it was not Anwar Ali Sarkar. So in that case, one of the theories which got adopted was that there is a compartmentalized idea that which we must look in what is the proximate article which appears to have been violated. So supposing in case it is a case of detention, you may say 22. Then no need to go to 14, 19 and something else. So therefore, the idea that we have today accepted that a particular action may fall in 2 or 3 different planks, 14, 19, 21. This is what we come to about and say that the entire action is violative of all 3 rights of mind. That theory was not in vogue as a result of A.K. Gopalan. And for the first time, this Subba Rao, this is a judgment of 64, because that theory was buried for the first time in R.C. Cooper. So R.C. Cooper was a judgment rendered by Justice G.Seshagiri subsequently, but 2 or 3 years before that, the seeds were sown in one of the passages which says that this action could be bad under 19(1)(d) and 21. And there is nothing wrong in that. There may be slight overlap so far as these articles are concerned, and the action could still be bad on both counts. So therefore this case has significance on 2 issues. Number one, privacy, which got subsequently elaborated in Puttaswamy, and of course this theory that a violation could possibly be of combination of rights, not just compartmentalized idea of one single fundamental right. So there goes the 4th case by Justice Subba Rao. Now we come to the celebrated case, which is Devadasan. You know, under 15 and 16, after that judgment in Champakam Dorai Rajan, the first amendment came in and 15(4) got added. So 15(4) empowers the state to have any measures of amelioration so far as the scheduled caste, scheduled tribes are concerned, and in exercise of that power, there could be reservation. Similarly, under the original constitution 16.4 entitled or still entitles the state to come out with concept of reservation under 16.4. In a case which directly came purely under 15.4, in a judgment which is called Balaji, where Justice Rajendra Gadkar speaking for the court came out with this logic, and he said, but by very nature, 15.4 is an exception to the original clause which is 15.1. Because 15.1 says that no person shall be discriminated on grounds such as sex, religion, caste, creed, etc., etc. So therefore, non-discrimination is your principal idea under 15.1. Whereas reservation or special dispensation can come as what is called an exception to that general rule. And by very nature, the exception has to be lesser than the main clause. So the tail of the dog must be shorter than the dog. The exception must be shorter than the main provision. It can't be greater than the main provision. And therefore, as a thumb rule, Justice Rajendra Gadkar came out with this idea that exercise of power under 15.4 should not go beyond reservation of 50% seats. That 50% marker in our jurisprudence got developed only through Balaji for the first time. Now, Devadasan was not a case under 15, it was a case under 16, which is the government employment. What happened is that in state of Kerala, there used to be a reservation which was getting employed, and the quotient was 17.5%. Seats in a particular year in whatever are the vacancies should be reserved for the scheduled caste and scheduled tribe. It so happened that for successive 2-3 years, there were not enough number of candidates. There was a carry forward rule that whatever are the vacancies of the previous year, they could be transferred or added on to the next year. And in the process, after 3 years, it so happened that against the earmarked percentage of 17.5%, what finally got reserved was more than 60%. Now, saying that this 60% now violates Balaji principle, which is 50% marker, so therefore the challenge was raised in this court. Justice Mudolkar, speaking for the majority, in a constitution bench for himself and 3 others, which are Das, acting CJI, Raghuvar Dayal, and then Raghuvar Iyengar, adopted what is called Balaji principle, which was peculiar to 15, and implanted the same principle in 16. Which would mean that the marker of 50% had to be adhered to, could not be transgressed. Now, what was the result of this carry forward rule? It was definitely going beyond 50%. So therefore, Justice Mudolkar in his final summation says that that rule which allows you to carry forward and go even beyond 50% is bad. So according to the majority, the rule itself was bad. Justice Subba Rao struck a dissenting note. Subba Rao said that 16.1 undoubtedly sails along the same line as 15.1, which says that every person shall not be discriminated on grounds such as so and so, so and so. Yes, that is your normal philosophy. 16.4 gives you the right to carve out an exception through reservation. But this theory that 16.4 is an exception to 16.1 or 15.4 is an exception to 15.1 is not correct. These are substantive provisions. 16.4, he said, is a substantive provision. And therefore, if the government concerned is of the view that there has to be a reservation going way beyond 50%, they could still be justified. In fact, Subba Rao in one sentence goes on to say that there can even be 100% reservation through this kind of carry forward law. There can be. So when it comes to empowering the government, according to him, there will be no shortcuts on that. You have to accept that's the logic which will go that way. His was the dissenting note. So for the first time, somebody advocated and projected an idea that 16.4 is not an exception to 16.1, but is a substantive provision in itself. Because the entire logic in Balaji is what? Because 15.4 is an exception, so therefore exception can't be greater than the main, and therefore it needs to be lesser than 50%. But if you demolish that idea at the root itself and say that it is not an exception but a substantive provision, then you need not worry about the castle which gets built on that edifice. And this is how demolished that castle. Now, of course, this was a dissenting note. That was picked up in Thomas by 7 judges. And 4 out of those 7 judges accepted what Subba Rao said to be the correct proposition and disposition of law. So they said that's the correct understanding of 16.1 and 16.4. The same logic then got picked up by Justice Reddy in Indira Sami. Because one of the questions was that because in those days 15% used to be the reservation for scheduled castes, 7.5% for scheduled tribes, and 27 was the marker for OBCs, which was very, very close to 50% mark, which is 49.5%. So one of the questions which was agitated was, just as Mr. Palkiwala addressing, I still recollect as a junior, I used to sit in that court, that he said that what is going to be the merit of this country if 49.5, which is almost half the persons are going to be, seats are going to be filled up, otherwise than on merit, what is going to be the fate or the fortune of this country? He was very, very visibly agitated. But that submission got rejected on the ground that 16.4 is an independent substantive provision. It is up to the state to see whether what kind of reservation. Because if you see, Mandal had recommended something like, he had found that the backward communities in the country are 54%. So as against that, what got reserved was only half of that, which was 27%. So therefore, according to the judgment, Justice Reddy, he went on to say that there are no states in the northeast, Manipur, Meghalaya, Mizoram, etc., where the scheduled tribe population is more than 70%. So how do you apply this Balaji logic every time? So it has to be that leeway has to be given to the state government or the concerned appropriate government to come out with whatever, according to them, is the appropriate marker. Then what does that mean? What was the dissenting note in Devadasan was picked up in Thomas and became part of our ethos, jurisprudence in Indira Sami. Not just that, thereafter comes the Constitution Amendment 16.4b, which now says expressly as part of our Constitution that if by virtue of, if the state is taking resort to what is called backlog vacancies, filling up backlog vacancies by carry forward rule, then whatever is the number of that backlog vacancies will not be taken into account while considering what is 50% mark. So in essence, accepting what Subba Rao said. So that's why look at the kind of foresight of this man at every juncture, that he could think of a problem rather than beating or following the beaten track. He was one person who believed in what is called ekla chalo rahe. And now I come to the last one. Which is Makhan Singh. We are well aware of ADM Jabalpur. What happened in ADM Jabalpur, one of the celebrated dissenting note by Justice Khanna is what? Even during emergency, fundamental rights cannot be suspended. Recourse to remedies in court is something which is part of your right and you can avail of that remedies despite the fact that there is declaration of emergency. We have come to accept that. In a similar situation, when there was a Chinese aggression in 1962, there was an external emergency. Of course, in ADM Jabalpur, we were considering what is called internal emergency. This time it was external emergency. Under 359, there could be what is called the effect of such declaration of emergency would be that in case of a detention, certain rights would get restricted. That one couldn't approach the court under 32 to 26, so on and so forth. That very regime was under challenge in Makhan Singh. And Gajendra Gadkar, speaking for the majority, for himself, it is a bench of 7 judges. Justice Sarkar, Vanshu, Hidayatullah, Dasgupta and G.Seshagiri. Some of the finest judges of this court. What the majority judgment says is, go by the letter of 359. What does it say? That so far as right to approach the court under 32 to 26 would definitely stand curtailed. So he can't challenge the validity of that particular law. But Subba Rao went an extent further in his dissenting note or minority view. What did he say? That such an order will not disentitle a person from contending before the court that the grounds under the act by which I am supposed to be detained are not satisfied at all. Or my detention is not in conformity with the provisions of the law. I may not be able to challenge the law of detention, but I could still have challenges which are slightly lesser than that, and those challenges would be, one can say that very well, my order of detention is not in conformity with the law. The grounds for detention are not made out. Or I can go to the High Court and ask for any injunctive or any interim relief. So he opened the door for the detainees, which was closed ajar on such detainees through 359 operation. And that is something which paved the way, because if you see Khanna's judgment and those judgments in ADM Jabalpur, at every juncture you will find some reference to Subba Rao's judgment in this particular law, which is Makhan Singh. I have tried to cover about 6 or 7 judgments of Justice Subba Rao in the time which has been allocated and available to me. This is what perhaps I could do to the best of my ability. It was to place before you the judgments in proper perspective, what was the view of Subba Rao as opposed to what was the view of the majority, so that it gets into focus as to what his view was, and then see whether that view was subsequently adopted, accepted, acknowledged and followed. So therefore that's where lies the great creativity of that man. And this, to my mind, is something that Justice Subba Rao stands for. People say that if you see the articles on Justice Subba Rao, it will be with that kind of description, that here was a judge who was the avenger of fundamental rights, the man who stood by fundamental rights at every juncture, the man who stood for full enjoyment of fundamental rights by this citizen. Now comes the postscript. All through his life, 62 dissenting notes, correct? Some of them have become what is called the view of acceptance in our jurisprudence. One of his last judgments was Golaknath. There Subba Rao wrote for the majority. The bench decision of 11 tilted in favor of 6-5. What did 6 judges say? Subba Rao wrote for himself and 4 others. There is a concurrent view by Justice Rao. What is the majority? Again, somebody's inclination to preserve fundamental rights, even if there be a constitutional amendment which violates somebody's fundamental rights, that amendment can be struck down on that ground. So therefore, somebody who had been in minority, his views are getting accepted, where he was in majority and spoke for the court, that view was never accepted in Keshwanand Bharti. That's the irony of, the nature has some things, to up his sleeve. So therefore, that's where Justice Subba Rao stands for. Thank you so much.
Thank you very much, sir. Let us see a standing ovation to sir. A huge claps also, please. Thank you very much, sir. The way you explained it's a very serious, one can do PhD, interestingly. Those who want to judges, particularly women lawyers, they are very keen these days for designation and judicial. They have to learn from these interpretations and other things, dissenting and other things. Great. I request Muthu will give a vote of thanks. Please, Muthu.
We thank the Lordship Justice Lalit for coming here. The full house, the attendance that we can witness is the outpouring of love and affection that you still have the Lordships among the bar. And this is one such day where we are left longing for more. We just want to have many of them, not just one, many of them Lordships. And it's interesting that this topic about the 9 Chief Justices in India being delivered by the 49 Chief Justice of India. So we are really thankful for that. And coming back to what your Lordships had said about the judgments passed by Justice Subba Rao, it makes us wonder that when we talk about this court, Supreme Court as being a guardian of constitution or fundamental rights, the contribution made by Justice Subba Rao was immense. In fact, day in and day out we keep talking about fundamental rights, natural justice, and the first judgment, Radhesham Kare, talks about the principles of natural justice, and the second judgment, Vasveshwar Singh. So this is again about the principle of no one shall be condemned before being heard. So these are the judgments I think that even every student of law should always learn and should always keep in their memory. And most important thing is this, your Lordships, what I get to understand is that the judges of the past have inspired the judges of the present, and the judges of the present will inspire the judges of the future. Thank you, Lordships.
Small announcement, those who are not receiving Friday group messages, we have small leaflets are here, you can fill up and give back to me so that your names will be added particularly. They are also in that counter, those who are receiving, not necessary, those who are not receiving, please fill this and give it to me. Now Lordship, I know that my deadline, we go for a cup of tea, if at all typer.
Really, it's